Disability Rights Oregon lawsuit providing restorative treatment when unable to aid and assist in legal defense. We're going to go down for these more recent things going on. The order on vacating fines exemption and the motion to modify remedial order. This is OAC v. Mink. Here, let's go check this out. I kind of want to read the whole thing, dude. Let's see. So basically, the federal judge is not letting them get away with pausing their $500 a day fines, even if they blame it on a bunch of it's the sheriffs or it's the jail deputies. It's not going to go with that. So Disability Rights Oregon, Metropolitan Public Defender Services, Inc., and A.J. Madison versus Sajal Hathi in her official capacity as Director of the Oregon Health Authority, and James Diegel in his official capacity as Interim Superintendent of the Oregon State Hospital. Currently pending before this court is Plaintiff Disability Rights Oregon's motion to vacate orders permitting fine exemptions. Plaintiffs Metropolitan Public Defender Services, Inc., MPD, and A.J. Madison have not stated a position on the motion. Defendants Dr. Sajal Hathi in her official capacity as Director of the Oregon Health Authority, OHA, and James Diegel in his official capacity as Interim Superintendent of the Oregon State Hospital oppose the motion. No party has requested oral argument. For the reasons stated herein, DRO's motion is granted. Background. The factual background of these consolidated cases is well set out in prior opinions and orders, including the court's June 6 opinion and order, the contempt order. See Op and Order June 6, 25. The following background focuses only on facts that are particularly pertinent to the subject motion. In the contempt order, the court made several relevant rulings. The court first found that defendants are in contempt of the permanent injunction that has been in place in this case since 2002. Based on this finding, the court ordered the implementation of monetary fines and certain remedial measures. Specifically, the court imposed monetary sanctions in the amount of $500 per class member per day and directed defendants to submit a proposed calculation of contempt fines on the 15th day of each month until defendants reach substantial compliance with the permanent injunction. The court also changed the role of the then neutral expert in this case, Dr. Deborah Penals, to court monitor, and additionally ordered that periodic status conference to take place every 90 days. Defendants appealed the contempt order. Notice of appeal to the Ninth Circuit, 6/17/25. On June 16, 2025, in compliance with the contempt order, defendants filed their first report regarding the calculation of contempt fines. First fine calculation. Okay. The report indicated that there are occasionally delays in admission to OSH that are caused by circumstances outside defendant's control, where such OSH offers a bed to a county jail for an individual being held therein, but the jail declines to transport that individual. Order of June 17, 2025. June 17th, the court ordered defendants to file a supplemental report addressing two specific questions. When a bed is offered to and declined by a county jail, what happens to the individual who would have been taken to OSH if not for the jail's declining to transport? In other words, is that individual offered the next available bed, moved to the bottom of the list, or something else? And if the same circumstances occur that such an individual remains housed at OSH longer than deemed necessary by OSH, what is the mechanism to return that individual back to the appropriate county's jail? On June 18, defendants filed the supplemental report and proffered answers to both of the court's. Okay, I'm going to read this footnote. Okay, though this is not a class action, the court defined the term Bink-Bowman class members to mean all criminal defendants determined by Oregon courts to be unfit to proceed to trial due to either an inability to aid and assist in their own defense or a court order finding them to be guilty except for insanity. Since the issuance of the contempt order, defendants have described those subject to inclusion in the fine calculations as all persons ordered committed to OSH pursuant to Oregon Revised Statutes 161.370. The court has recognized defendants' description to be consistent with the language in the contempt order. The court now uses the term class members to refer to these individuals. On June 18, defendants filed the supplemental report and proffered answers to both of the court's questions. Separately, but also June 18, defendants filed a motion for stay, seeking a stay of contempt order pending defendants' appeal to the Ninth Circuit. Motion for stay. Okay. Disability Rights Oregon, June 20, filed a brief regarding the calculation of contempt fines, which the court construed as an objection to the defendant's first contempt fine calculation report. Specifically, DRO objected to the defendants excluding from the contempt fine calculations any delays based on jails declining to transport, arguing that such delays are not ultimately outside defendants' control and that the assessment of contempt fines should reflect the state's ultimate responsibility for timely treating incapacitated criminal defendants. DRO also noted that it is inherently problematic to allow OSH to make the subjective decision about whether delays are the fault of OSH or of recalcitrant county sheriffs, particularly where the imposition of contempt fines incentivizes defendants to minimize their own financial responsibility. Defendants filed a response in opposition to DRO's objection, June 27, 2025. Okay. June 15, defendants filed their second contempt fine calculation report. Defendants again excluded from the proposed amount any fines for days where the delay was caused by circumstances outside defendants' control. August 6th, court denied defendants' motion to stay and sustain DRO's objection to the first contempt fine calculation report. Therein, the court reasoned, in relevant part, the law of this case and the Ninth Circuit makes clear that the onus falls on the defendants to comply with the permanent injunction. In addressing defendants' motion to stay the permanent injunction, Judge Panner made clear that the 7-day period must be calculated from the date the court order is issued, not the date OSH receives a copy of the court order, in part because the defendant's desire for administrative convenience should not trump the needs and rights of the persons requiring hospitalization. Order May 28, 2002. Likewise, in affirming the permanent injunction, the Ninth Circuit conclusively held that it is OSH, not counties, that has the duty to accept incapacitated defendants once they have been certified as such by the Circuit Court. Mandate from the U.S. Court of Appeals. The Ninth Circuit called OSH solely responsible for satisfying the permanent injunction and noted that lack of funds, staff, or facilities cannot justify the state's failure to provide incapacitated criminal defendants with the treatment necessary for rehabilitation. Quoting Olinger v. Watson. Okay. Based on this reasoning, the court sustained DRO's objection, directed defendants to resubmit the first and second contempt fine calculation reports, and ordered that all future fine calculation reports conform to the rulings of the court's opinion and order. Defendants promptly resubmitted their first and second contempt fine calculation reports. Defendants also appealed the court's denial of the motion for stay. August 15th, defendants submitted their third contempt fine calculation report. In this report, in compliance with the court's opinion and order, defendants included fines relating to days that resulted from delays outside of defendants' control. On September 4th, the court issued the first judgment regarding the contempt fines. The first contempt fine, defendants appealed the first judgment. Notice of appeal to Ninth Circuit. On September 8th, the court held the first quarterly status conference following its issuance of the contempt order. Minutes of the proceedings for September 8, 2025. On the record, defendants made 3 requests to the court regarding the contempt fine process. First, defendants asked the court exclude from calculation of contempt fines days resulting from court clerks' failure to timely send commitment orders to OSH. Proceedings of September 8, 2025. Second, defendants asked that the court exclude from the calculation of contempt fines days resulting from the failure to transport persons from jail to OSH, so long as defendants can show they provided timely notice to the county jail, issued a constitutional rights directive to the jail, and informed the court of the circumstances. Third, defendants asked that the court permit them to pay the first and any future judgments related to contempt fines with state-issued checks as opposed to cashier's checks. The court immediately granted the third request and provided plaintiffs an opportunity to be heard as to the first 2 requests. MPD inquired as to the hypothetical situation regarding the impact of defendants' proposed exclusion request on a delayed transfer, at which point the court reminded the defendants are always to work with Dr. Pinos as the court monitor. MPD inquired as to how the court wanted to administer those types of issues if they arise, whether the court monitor would be authorized to administer. The court confirmed that the court monitor would be authorized to administer issues related to defendants' proposed exclusion requests. DRO opposed the proposed exclusions. Regarding the first proposed exclusion, DRO suggested ideas for how defendants might build a belt and suspenders double checking process to prevent court clerks from failing to send timely send commitment orders to OSH. DRO did not, however, offer further argument regarding the second proposed exclusion. Upon consideration of the parties' arguments, the court granted both of defendants' requested exclusions and asked defendants to continue to work with the court monitor with regard to future fine calculation reports. September 15, defendants filed the fourth fine calculation report. In it, defendants noted proposed exclusions in red and described their process working with the court monitor to review fine exclusions. October 1, defendants revised a fourth fine calculation report, again noting proposed exclusions in red, and this time noting whether the court monitor approved each requested exclusion. Also, October 1st, defendants filed an unopposed motion to adjust headlines for submitting proposed fine calculations, asked to adjust the schedule so as to provide plaintiffs and the court monitor additional time to review defendants' proposed exclusions and supporting documentation before Dr. Penals makes her decision as to whether to grant any exclusions. On November 3, defendants filed their fifth fine calculation report. December 1, defendants filed their sixth fine calculation report. In both reports, defendants again noted proposed exclusions in red and whether the court monitor approved each requested exclusion. December 8, the court held the second quarterly status conference following the contempt order. December 9, court issued the second judgment regarding contempt fines. Defendants appealed the second judgment. Notice to the appeal to the Ninth Circuit. January 2nd, 2026, defendants filed their seventh fine calculation report. Defendants again noted proposed exclusions in red and whether the court monitor approved each requested exclusion. January 8th, the court issued the third judgment regarding contempt fines. Defendants appealed the third judgment. DRO, January 23, DRO filed the instant motion to vacate orders permitting fine exemptions. Defendants filed a response in opposition. DRO filed a reply in support. February 3, defendants filed their eighth fine calculation report. March 3rd, defendants filed their ninth fine calculation report. Discussion. Before turning to the substance of DRO's motion, the court addresses the issue of conferral. DRO's motion to vacate asserts that defendants willfully declined to confer by telephone or in person after an exchange of emails. Defendants respond that their counsel engaged in meaningful, substantial conferral with DRO via email. The plain language of Local Rule 7-1A1 provides in relevant part that a movement must certify that either A, the parties made good faith effort through personal or telephone conferences to resolve the dispute and have been unable to do so. B, the opposing party willfully refused to confer. Direction of Local 7-1A1 is clear, and here defendants concede that they did not confer via personal or telephone conferences. Defendants are reminded of their obligation to comply with this rule to its letter. Motion to vacate orders permitting fine exemptions. Turning to the substance of the motion, DRO asks the court to vacate any verbal orders and written order allowing Dr. Penals to grant exemptions to fines for delays caused by sheriffs and court staff. In support of the request, DRO argues that although defendants submitted an unopposed motion asking this court to allow them to submit documentation to Dr. Penals and allow her to deduct fines due in part to delays from the failure of state court staff and county sheriffs, defendants now, on appeal to the Ninth Circuit, complain that the process assigns Dr. Penals the role of adjudicating whether OSH is entitled to certain exemptions and thereby delegates the quasi-judicial function to Dr. Penals, a non-judicial officer. DRO notes that defendants also complain on appeal that the court has not established any procedure for challenging Dr. Penals' determination and call the process an improper delegation. DRO also argues that the granted fine exemptions have not fostered sufficient reductions in constitutional violations to justify their continuation. Therefore, DRO asserts requiring Dr. Penals to spend hours reviewing the state's communications with court staff and sheriff's offices is not a good use of our time and energy. In response, defendants concede that the court has jurisdiction to amend or modify its orders regarding fine exclusions, but argue that it should not do so because DRO's motion materially misstates the record before the court and misunderstands the scope of the defendant's appeal from the court's contempt order, and there is simply no present reason to amend or modify the order permitting fine exemptions. On the first point, defendants asserted that DRO misdescribes the opposed motion defendants filed, which was merely a motion to adjust deadlines and not a request for Dr. Pinos to adjudicate fine exclusion requests. That process, defendants argue, was not proposed, only acquiesced to by defendants. On the second point, defendants reasoned that the orders permitting fine exemptions appropriately prevent defendants from being fined for circumstances over which they have no control, because in such circumstances, fines can have no coercive effect. And contrary to DRO's assertion, and to the extent relevant, since the fine exclusion order issued, there's been a reduction in admission delays caused by jail transport issues, meaning the process is not a misuse of Dr. Pino's time. The court declines to wade through the parties' many disagreements regarding the appellate record and the nature of defendants' arguments on appeal. The court need not reach these arguments to find that amendment of its prior orders permitting fine exemptions is permissible and appropriate under the circumstances at hand. The court therefore exercises its discretion and inherent authority to vacate its prior orders allowing Dr. Pinos to grant exemptions from fine calculations for delays caused by sheriffs and court staff. Defendants are ordered to provide the court with proposed calculation of all fines previously exempted from the first through third judgments issued in this case, located ECFs. Okay. These judgments encompass defendants' first through seventh fine calculation reports located at, upon receipt of this proposed calculation and barring any objections needing resolution, the court will enter a supplemental judgment encompassing the calculated amounts previously excluded. Consistent with the law of this case in the Ninth Circuit, August 6, 25, the court will no longer exempt from the contempt fine calculations delays related to sheriffs and court staff. Defendants are further ordered to resubmit their 8th and 9th proposed fine calculation reports without any delays exempted. The court will enter a fourth judgment encompassing the amounts set forth in the resubmitted 8th and 9th proposed fine calculation reports. Conclusion. For the reasons stated herein, Plaintiff Disability Rights Oregon's motion to vacate orders permitting fine exemptions is granted. Accordingly, the court's prior orders allowing Dr. Pinos to grant exemptions from contempt fine calculations for delays caused by sheriffs and court staff are vacated. Within 14 days, defendants are ordered to provide the court with proposed calculation of all fines previously exempted from the first through third judgments issued in this case as outlined in this order to be included together in a supplemental judgment and resubmit their 8th and 9th proposed fine calculation reports without any delays exempted. Moving forward, the court will no longer exempt from the contempt fine calculations delays caused by the sheriffs and court staff. And this is 26 March 26, Adrian Nelson, U.S. District Judge. And so for just regular people, basically the Oregon Health Authority is being fined for not having prompt Oregon State Hospital relief for people who are allegedly needing hospitalization in order to face their criminal charges. And that is being viewed as a disability right. And the fines are going into a sort of like an escrow to assist in rebuilding of infrastructure. So the fussing and fighting over the fines is almost, in a way, kind of silly because they basically just need to rebuild Oregon.